delegation.
15 delegation list you have here, it's on the desk.
Here. Here. Muy buenas tardes.
Good afternoon, colleagues, distinguished members of the delegation of Cyprus, members of non-governmental organizations. Welcome. I call to order the 3,142nd meeting of the Human Rights Committee. This is a repeat appearance by the Republic of Cyprus. You have all received the list of issues and replies. We're going to have a very fruitful dialogue this afternoon and tomorrow morning. So without further ado, I'll give the floor to Ms. Lida Korsumba, Her Excellency, to deliver her introductory statement. You have the floor, Your Excellency.
Thank you, Mr. Chairman. Mr. Chairman, distinguished members of the committee, it is indeed an honor and a privilege for me and the other members of the delegation of the Republic of Cyprus to appear before your committee in order to present and elaborate on the fourth periodic report of Cyprus submitted under Article 40 of the International Covenant on Civil and Political Rights. Please allow me to present the members of our delegation. Myself, the Law Commissioner of the Republic of Cyprus, an independent officer directly accountable to the President of the Republic with a fixed mandate of 6 years, having competence inter alia to make proposals for reform of the national legislation with a view to achieving compatibility with international human rights instruments like the ICCPR, and to prepare and present the country reports under such international treaties. His Excellency, Ambassador Andreas Ignatiu, Permanent Representative of the Republic to the United Nations in Geneva, Mr. Dimitris Samuel, Deputy Permanent Representative, Mrs. Natalia Andreou Panagiotou of the Ministry of Labour, Welfare and Social Insurance, Mrs. Athina Dimitriou of the Ministry of Justice and Public Order, Mrs. Anna Argyropoulou of the Ministry of Interior, and Mrs. Maria Sologianni, Advisor on Human Rights Issues at the Permanent Mission. Mr. Chairman, the committee has before it the following documents. The fourth periodic report of Cyprus, dated 14th December 2012, our replies to the list of issues, dated 22nd December 2014, and our most recent court document, submitted on the 1st July 2014. The concluding observations of the committee in relation to the third periodic report, as well as the fourth periodic report and the replies to the list of issues, have been made available to the public, having been posted on the official website of the Office of the Law Commissioner. Mr. Chairman, the Republic of Cyprus attaches great importance to the safeguarding and respect of human rights. The Constitution upon which the state is structured has an extensive Bill of Rights which incorporates all fundamental rights enshrined in the basic and universal human rights instruments. Furthermore, Cyprus has ratified the majority of binding universal and regional human rights instruments. These include those developed under the auspices of the United Nations, the ILO, UNESCO, ICAO, and others, as well as those developed under the auspices of regional institutions, namely the Council of Europe, the European Community European Union, and the CSC-OSCE. The International Covenant on Civil and Political Rights, as well as the Sister Covenant on Economic, Social, and Cultural Rights, were ratified by Cyprus 40 years ago. This demonstrates, I believe, the importance Cyprus attaches to the promotion and protection of human rights within its jurisdiction. The government of Cyprus closely cooperates with all UN monitoring bodies and mechanisms, as well as with all similar European bodies. It regularly submits data and reports as required in compliance with its international obligations in the field of human rights and freedoms. Cyprus is up to date with its treaty reporting obligations. I am in the regretful position to remind you that due to the continuing illegal occupation of 36.2% of its territory by Turkish military forces, the state party is unable to ensure application of civil and political rights to persons residing in that part of the country, which is de facto outside its effective control. This fact is reflected in the annual reports of the Office of the United Nations High Commissioner for Human Rights on the question of human rights in Cyprus, the latest one having been published last January. Mr. Chairman, a detailed analysis of the developments in legislation, administration, government policies, and national action plans was given in our country report and the replies to the list of issues, covering the period up to December last. Therefore, in my today's address, I will concentrate on outlining the developments thereafter. Detailed information concerning the whole period under review will be given during the interactive dialogue which will ensue. As to non-discrimination, following the recommendations of both the European Commission Against Racism and Intolerance and the anti-discrimination body, the Ministry of Education and Culture has compiled a code of conduct against racism and a guide for managing and reporting racist incidents in schools, taking into account the views of experts in the field of intercultural and anti-racist education. Specific actions are currently being implemented in schools pursuant to this. A police policy statement for the prevention, handling, and combating discrimination and racist crime has been agreed upon between the police and the Ombudsman's office. This statement restructures, elaborates on, and enhances the previously existing framework within the police. It calls for the need to further develop proactive and deterrent action, victim encouragement, support and protection, and highlights the importance of more effective intervention and investigation measures. Following intervention from the Ombudsman in her capacity as the anti-discrimination body regarding the necessity for regulating cohabitation outside marriage of different sex as well as same-sex couples, the Ministry of Interior has prepared a bill on the establishment of a Civil Partnership Pact. This has been put to an open consultation process and is now due to be submitted shortly to the House of Representatives for enactment. With regard to education, a school mediation program is offered for teachers and students of primary and secondary education level as an alternative approach to discipline. Its implementation enables students to resolve conflicts without resorting to violence through compromise and restorative actions, thus creating a culture of understanding, respect, and tolerance. In cooperation with the Cyprus Red Cross, the police is currently implementing a program providing psychological support to detainees at the Menogia Detention Center and their families. When examining cases concerning families, the primary consideration for the application of the relevant laws, that is, the Aliens and Immigration Law and the Refugees Law, is the best interest of the child. This is specifically stipulated in the said laws. The detention of persons awaiting removal is only used as a measure of last resort if other effective measures cannot be implemented, and only for the shortest period of time necessary for the process. These matters are strictly and specifically regulated by the Aliens and Immigration Law. As a result of close monitoring by the Commissioner for Children's Rights, a policy decision was issued by the three ministers having competence in the matter to enhance effective cooperation of all government services concerned with a view to eliminating incidents of separation of children from their mother or single parent. In respect of the principle of non-refoulement, where a non-EU national in detention submits an application for international protection, the deportation order is suspended. The application is examined under an accelerated procedure. If a decision is not taken within 30 days, the person is released. A leaflet specifically on the right to request free legal aid is given to the applicants at the time of submission of their application. The Ombudsman, in her capacity as National Preventive Mechanism, closely monitors the authorities and ensures their compliance with the international standards. As of 2014, the state is in full compliance with the Ombudsman's recommendations concerning the penitentiary system. In this regard, the first phase of the reform plan has been recently completed with success. Due to the time constraints for this address, detailed information can be given during the interactive dialogue. The Ombudsman and the Ministry of Justice have jointly issued guidelines last April for the prevention of suicide incidents in prison and detention centers as a measure to prevent such attempts. Since October last, there have been no attempts of self-harm, including suicides. The Ombudsman's office participates in a training program of the prison staff on basic concepts of human rights and non-discrimination issues. Through the Grants in Aid scheme, financial and technical support is provided by the Social Welfare Services to the Association for the Prevention and Handling of Violence in the Family, an NGO, for the support of the Crisis Center, the shelter, and the European support hotlines, for instance, that for missing persons, that for support of children, and some others. Through the Progress Programme, the Ombudsman has launched a campaign co-funded by the European Commission in order to raise awareness, prevent and combat violence against women. Inter alia, a number of training seminars targeted to key professionals were organized. In relation to stalking, an amendment to the existing criminal provisions is in the pipeline in order to introduce this notion in the national criminal law in line with the Istanbul Convention. The criteria for the employment of domestic workers are under examination by the Civil Registry and Migration Department with a view to simplifying the procedures and eliminating uncertainties that could lead to unfair treatment of these workers. As regards trafficking in human beings, the national referral mechanism is being revised so as to ensure its alignment with the new legislative provisions. The acquisition of the services of an independent external evaluator is in the pipeline. As to migration, regarding the Kofinu Reception Center, its capacity has increased from 70 to 400 places, and living conditions have been significantly improved. A new emergency reception center for temporary accommodation was established in 2014 in order to enhance preparedness for possible mass influx. In September last, this center was used for the first time to accommodate the 337 persons, Syrians and Palestinians, who had been rescued at sea. In December 2012, an agreement between the Republic of Cyprus and the IOM was signed, on the basis of which the establishment of an IOM office in Cyprus was agreed. This cooperation will further strengthen the efforts towards a comprehensive migration policy. Local authorities are increasingly involved in programs for the smooth integration of migrants in their area. Examples of these are the program run by the municipality of Geroskipu under the title Together for an Open Society, which provides services aiming to assist in the daily issues of concern for migrants and at the same time targeting their interaction with the local society and their active participation in the social life of the community. And secondly, the program run by the municipality of Nicosia, funded by the Immigrant Information Office, providing free psychological support and other services. Following a report of the Ombudsman in relation to the policy of requesting a DNA paternity test when examining applications for registration of children born of mixed marriages, the Minister of Interior instructed the competent department to terminate this practice. Following the confiscation by the police of photographs displayed at an exhibition organized by Accept LGBT Cyprus as obscene and therefore illegal, the Ombudsman issued a report elaborating on the freedom of artistic expression. The Attorney General, adopting the views of the Ombudsman, decided not to proceed with a criminal investigation of Accept. The Ministry of Education and Culture has put additional emphasis in the implementation of, inter alia, the following programs: operation of the zones of educational priority, where additional resources are provided to vulnerable groups of students to combat school dropout and reduce school failure and youth delinquency. The operation of the Task Force on School Violence to provide immediate support and guidance to schools facing incidents of violence and youth delinquency, and the policy regarding prevention and intervention measures for school bullying. For this purpose, several guidelines and a manual for teachers of all grades have been issued, and in-service training of teachers is being organized. In addition, a circular was sent to all schools on the policy of the ministry concerning bullying, which includes all help pipelines for students, parents, and teachers to request help and information. Since 2014, the Ministry of Justice and Public Order has allowed free access to prisons facilities following a request by inmates to the representatives of any religious denomination. An important development during the period under review of a general impact was the amendment of the institutional law of the Ombudsman last year, so as to strengthen the obligation of the state to abide by her recommendations. More precisely, the new provisions give power to the Ombudsman, after submission of her reports, to consult in any way she deems expedient with a competent authority as to the manner in which the latter will comply with the recommendations of the Ombudsman in order to resolve the problems of the individual. Where the Ombudsman is not satisfied with the results of this consultation, she is empowered to bring the issue to the attention of the Council of Ministers and the House of Representatives, and also to publish the refusal or failure of the competent authority to comply with her recommendations. Mr. Chairman, during the period under review, there were significant positive developments regarding compliance by Cyprus with the letter and the spirit of the ICCPR. Many anti-discrimination laws were enacted and policies adopted. Several national action plans were initiated. Independent control mechanisms were established, such as the Anti-Discrimination Body, the Independent Authority for the Investigation of Allegations and Complaints against the Police, and the Complaints Committee for the Menoya Center. The educational reform has developed as an ongoing process. All this aiming at promoting civil and political rights and combating racism and all forms of discrimination. Cyprus is committed to continue working for the further advancement of awareness raising and education and effective implementation of human rights in general and civil and political rights in particular, and to taking all necessary measures towards that goal despite the economic crisis which has curtailed resources and negatively affected social cohesion. The greatest challenge for the future is to maintain and secure the necessary resources for the effective implementation of the institutional mechanisms and the further development of programs promoting equality and safeguarding the enjoyment of civil and political rights so as to prevent any setback in what has been achieved so far. After all, respect of human rights in times of hardship should not be regarded as an economic burden for the society, but should be a prerequisite for social development and growth. Thank you, Mr. Chairman.
Thank you very much, Excellency. Voy a señalar.
I will now outline the procedure. For this afternoon, we have 30 questions on the list of issues. This afternoon, it is planned for the committee to have a dialogue with the distinguished delegation concerning the paragraphs 1 to 15. That is exactly half of the list of issues. After the questions have been asked by colleagues, we will have a break to give time to the delegation to prepare its replies, of course, and then we will hear the replies from the delegation. Subsequently to that, colleagues will have a chance to ask follow-up questions. And thus we will have a very enlightening exchange of views. I think the delegation is well acquainted with these procedures since it regularly appears before the treaty bodies. This is the fourth time you've come here to our committee. So I will first of all give the floor to my colleagues who have requested the floor.
The list is Mr. Shani. Mr. Shani, you have the floor, sir.
Thank you, Mr. Chair. Let me first extend a very warm welcome to the delegation from Cyprus. There has been a long gap between the previous appearance of the state party before us and this appearance. I hope this is not related to the fact that we have opened our concluding observations of 1998 with congratulating the state party for the timely submission of the report. Still, it is better late than never, and it is certainly, although the report has been submitted 10 years after the date in which it was supposed to be submitted, I do thank the state party for submitting a very comprehensive report, a very professional report, and also very comprehensive answers to the questions that we have presented in the list of issues. I believe that the material before us does clearly show that Cyprus is committed to the promotion of human rights, has taken many steps towards ensuring better realization of the rights included in the covenant, but also acknowledges that more works need to be done to overcome existing obstacles, both obstacles that are conflict-related and non-conflict-related, obstacles that originate from the state of the economy, and for more general political and social factors. I will be covering during my intervention 4 issues from the list of issues, issue number 1 and issue number 2, and then issues number 11 and number 15, and some of my colleagues would be covering other issues from the segment that we will be addressing today, namely issues 1 to 15. Now, I would want to start dealing with the Office of the Ombudsman, and again to start my remarks with commending the State Party for its commitment to strengthen the institution of the Ombudsman, and also to express our pleasure of the news that the process of applying for accreditation to the International Coordination Committee is on its way. We would wish the delegation, however, to explain to us what is the factor, what is the reason why the Ombudsman had been prevented up until now to recruit her own personnel for the Office of the Ombudsman? And perhaps more generally, does this delegation believe that the resources that have been provided to the Office of the Ombudsman allow it to effectively implement its mandate, which is an extremely broad mandate, including on top of the Ombudsman function also the roles of the National Equality Body, the National Mechanism for the Prevention of Torture, the Independent Mechanism for the Implementation of the Convention on the Rights of Persons with Disabilities, and the National Institution for the Protection of Human Rights. This is a tall order, and the question is, does the office have enough resources to meet all of these different functions? Can you explain to us also in this respect, how does the process of approving the annual budget of the Office of the Ombudsman take place in Parliament, and does it have sufficient guarantees for the independence and the effectiveness of the office? And finally, with respect to that office, the issue of languages. Is it true that the office does not employ Turkish-speaking staff? This is information we have received. I don't know. I want the delegation to provide us with information that confirms or refutes that information. Is the work published in Turkish? Are the outputs, the reports, are they published in Turkish? Now, I see that the website of the office does have a Turkish site as well, on top of, besides the English and the Greek sites, but it appears as if the information on the Turkish website is rather limited in scope. So I would appreciate your remarks on this. Now, with respect to issue number 2, which deals with the interface of human rights, the covenant, and the conflict situation in Cyprus, there is no doubt in our eyes that the prolonged division of the island into 2 areas continues to constitute an obstacle for the full implementation of the covenant and the full enjoyment of human rights by all residents of the island. Can you elaborate to the committee what you deem to be the most serious conflict-related challenges that are confronting your state in implementing the covenant? And specifically, how does the situation on the ground affect the follow-up on the investigations of the Committee on Missing Persons? And to what extent are human rights issues and problems discussed in the context of the new round of negotiations, both with respect to the end state arrangements, but also with respect to interim questions such as travel, accountability, residency, access to religious sites, etc. To what degree are human rights part of the political negotiation? Issue number 2 also deals with the issue of the role of women in the peace negotiations. And there, I'm afraid, we did not receive information in the reply to the list of issues that directly responds to our concern, to our concerns in that regard. The question we have is whether Cypriot women were ever part of the negotiation process. I know that they have been involved in intercommunal talks. But it appears as if, by and large, their participation in the high-level negotiation phases had been relatively low. Now, this is an issue that also was raised in the recent UPR of last year for Cyprus, and I know that the state did accept 2 recommendations made in this regard. The question is whether since then anything has been done with respect to the integration of women in the political negotiations over the state of the island, and with respect to gender perspective, another point that was raised during the UPR and that the state accepted, whether the state has anything to report on the way a gender perspective has been put into place in order to shape its positions. To the best of the information, to the best of our knowledge, so far, for instance, when equality was discussed during the negotiations, the discussions revolved around ethnic equality and not so much around gender equality. And more generally, when human rights were discussed, it was typically not gender-based or gender-related human rights and some of the social rights which are associated with them. And I would appreciate the delegation's reaction to this issue. Now, moving on to issue number 11, which deals with corporal punishment. And here, this is an easy point to cover because the state did make significant progress in this regard. We are pleased to know that following a complaint that was filed against Cyprus by an NGO, the Association for the Protection of All Children, under the collective complaints mechanism of the European Committee of Social Rights under the Social Charter, the government confirmed that a bill amending the children law had been enacted, and that Article 54 that retained the ability of parents and teachers, etc., to punish their children had been repealed. This is very good news, of course, but the question is now as to the other side of the coin. What now happens to parents or to educators who use corporal punishment without having the authority to do so under the law? Are they being investigated? Are they being prosecuted? I realize that only a short time has passed since the annulment of Article 54, but I would welcome any information that the delegation can provide us at this stage. And finally, on issue number 15, which deals with the difficult issue of domestic violence, on which the delegation did provide us considerable information, including in the opening speech by the head of the delegation. And I should note that here too we are pleased to see the involvement of the Ombudsman in the fight against domestic violence. My concern is that the report, that the replies to the list of issues did mention the recommendations made by the Ombudsman, but did not mention what is the implementation status of these recommendations. Are they going to be implemented? When are they going to be implemented? And if not, why are they not going to be implemented? I'm stressing this point not only because of the importance of the issue to human rights and to women's rights, but also because it appears the data before us suggest a sharp rise in recent years in the number of complaints alleging domestic violence in Cyprus. According to some reports, tripling of the number of domestic violence complaints in the last 15 years, a statistic which I'm sure probably also reflects greater awareness to the problem of domestic violence. But the other side of the coin is that the number of investigations, prosecutions, and sentences is still very low, and this is a point which was recently flagged by the CEDAW committee with respect to Cyprus. And the concern about the big gap between the number of complaints and the number of sentences, one of the concerns is that this may suggest a high attrition rate of women or victims who are involved in the process and do not have the energy or the mental or other resources to follow it through till the end. So the question I have for the delegation is whether they can explain these trends, that we have more complaints but not significantly more legal proceedings, and also can the delegation comment on the sentencing policies. One of the concerns is that a large percentage of the penalties for domestic violence that are issued are monetary fines, and the question is whether this is commensurate with the severity of the crime in question. A few more questions in that department. Can you provide us with any information on the ways in which migrants and ethnic minorities are integrated in programs and policies against domestic violence? Did the state already open a rape crisis center? Is it planning, if not, to open a rape crisis center? And if not, what specialized services are currently offered to victims of rape and sexual assault? And my last point with respect to the legal framework, is there thinking about taking on board the suggestion of the Ombudsman of redefining violence and redefining the category, the group of protected persons under domestic violence legislation? Is it true that in the absence of an official complaint by the victim, or as a result of the withdrawal of the complaint by the victim, the policy of the police would be to automatically end the investigation of the case? Would welfare protection be afforded to persons who are victims of domestic violence but do not wish to submit a complaint, but we have good reasons to believe that they're victims of this? What about third country nationals? Do they get welfare services if they're victims of domestic violence? And finally, which is the central agency which is responsible for collecting, recording, processing information about incidents of domestic violence? I apologize for the length of this last intervention, and I look forward to hearing your reaction. Thank you.
Thank you very much, Mr. Shani. And next speaker on my list is Mr. Fatala. Mr. Fatala, you have the floor, sir.
Thank you, Mr. Chairman. I would like to join Mr. Shani in welcoming the delegation of Cyprus. And during this afternoon, I will deal with two issues, issues number 3 and 4. Related to the allegation that the nationality laws are applied in a discriminatory manner, and here some reports are making a clear mention to Asian origins. Your reply is very general and do not address the issue of the application of laws. It addresses only the law itself, but how is the application of this law? Also, the committee will welcome a clarification on the issue related restricting citizenship to children born to Turkish Cypriots, as reported to us also by some NGOs. There are several problemal issues in relation to this very particular issue that reports are saying that for some applications have been submitted a long time ago, sometimes it goes to 10 years ago, and there is no answer to these applications to have the citizenship, and there are no clear criteria concerning how the citizenship can be granted. Therefore, sometimes you have in one family one brother and one sister, and one is having the citizenship but not the other one. Concerning issue 4 in paragraph 17 of your reply, it is stated that as regards the fire of Koprulu Haji Ibrahim Aga Mosque in Limassol in 2012, the case was investigated and classified as undetected. Please explain how and why it was undetected. As for the general issue of preventing and combating discrimination, the committee welcomes the steps taken by the government as reflected in detail in paragraphs 11 to 20 of the written reply, particularly in relation to the Code of Conduct Against Racism, which was referred to in the presentation just done now. Also welcomes the Guide for Managing and Reporting Racist Incidents, and the application of the code on a pilot basis in 2014 and 2015. Please confirm that the application of the code is taking place and what effect or results it has achieved as a result of its application in the last few months. I know that the application started in 2014, but if there is any result on this, it will be welcome. It was reported to the committee also that since the last reporting period, racist attack against Turkish Cypriots and other nationalities have increased, and we have a good number of examples. I don't want to just mention these examples, but I would like to know if also if you can give us some clarification, some statistics or information to deny such allegations and to prove that such cases have decreased and not increased, at least in the last few years. And thank you, Mr. Chair.
Thank you very much. Now I pass the floor to Ms. Waterwell. Ms. Waterwell, you have the floor, madam.
Thank you, Mr. President. Let me join my colleagues in extending my warm welcome to the distinguished delegation of Cyprus. And let me congratulate you with the detailed report and detailed replies on the list of issues. You have made our life easy with the data you have provided us. We take note of the measures you have taken to close the gap in gender equality related matters between men and women. You are drafting, or maybe you have in the meantime finished drafting the new National Action Plan on Gender Equality. You have evaluated the previous plan. Can you tell me what the impact was or is compared to the situation before the action plan? And how is the gender balance in school? Two other colleagues are going to ask more questions on issue number 5, 6, and 14. And with that, I thank the delegation in advance for their answers. Thank you.
Thank you very much. Next speaker on my list is Mr. Situlsing. Mr. Situlsing, you have the floor, sir.
Thank you, Chairman. May I also welcome the delegation and thank the delegation for the comprehensive replies to our list of questions. We also find there's a good gender balance in this delegation, in fact, in favor of one gender. I shall be addressing issues numbers 7, 8, and 9. And issue number 7 relates to this long outstanding question of missing persons. In the replies, the question has been adequately addressed, and we also have the latest report of the Office of the United Nations High Commissioner for Human Rights on the general question of human rights, but which also deals with missing persons, and that report is dated January 2015 and addresses the period ending November 2014. Now, in paragraph 41 of your replies, it is mentioned that there were 502 Turkish Cypriots missing, and the year 2003 is referred to as to being the date when the families of Turkish Cypriot persons, missing persons, were informed as to whether they, as to having access to the information secured by the government. We would like to know how many of these families did apply for information, and concerning the 1,500 or so Greek Cypriots missing, could you please tell us in the final count how many are still missing? Now, it is alleged that the state party does not show the same sincere efforts in investigating cases of missing Turkish Cypriots. We would like to know whether there's this criticism is justified or no. Now, the third question I would like to put on this issue is about the results of these investigations. Is there any evidence of unlawful acts? Has there been any prosecution following the investigations carried out? And have the perpetrators been traced and punished for, in these cases of missing persons? In the Göttingen case before the European Court of Human Rights, which went to the European Court of Human Rights, the issue has been raised as to why the applicants in this case could not have recourse to the courts to challenge the administrative decision taken concerning these investigations. Could you please enlighten us on this and as to whether the attitude of the state party has remained the same? Then in the report of the High Commissioner, there are some positive developments, for example, about visits to places of pilgrimage on both sides, that is in Cyprus itself and in northern Cyprus. Are these positive developments going to impact on searches concerning missing persons in northern Cyprus? Have there been developments about access to archives, access to military areas, especially to the Committee on Missing Persons of the United Nations? And my last question on issue number 7 is about redress to relatives of victims. Are there schemes for psychological rehabilitation? Are there measures taken to grant compensation to the families of victims? The next issue I'll address concerns issue number 8 about police violence, or so-called police brutality. We take good note of the numerous positive steps which are listed out in the replies, steps which have been taken to eliminate this problem, and the different bodies or mechanisms set up to deal with this problem. We do hope that these measures are fully implementable and that they don't just remain on the statute book. On the other hand, we are concerned with the low rate of reported cases and convictions. You have very gracefully put annex number 4 to your list of replies, which gives statistics on these cases. And we find that from 2006 to 2010, there were 13 cases which went to court. And it would appear that there were 128 complaints. Could you please tell us whether this figure is exact? So out of 128 complaints, 13 cases went to court. However, in 5 cases, there were nulli prosequis filed by the Attorney General. There were acquittals in 4 cases. The case was suspended the 2 cases were suspended because the victims did not turn up. And there's still 1 case pending before court. So in the final result, there was only 1 conviction where the perpetrator was fined 1,000 euros for a case of assault. And in the same annex, you tell us that there are 8 cases pending before court as from 2011. So my question is, why are there so few cases in spite of your having set up this independent authority for investigations of complaints, of allegations and complaints against police? And on this authority, we would like to know how far it is still fully independent, how far does it report to the Attorney General. You have mentioned in paragraph 55 of your replies that it is subject to the Attorney General's directions. Now, will you kindly explain what this means, subject to the Attorney General's directions? And it is also mentioned somewhere that it is the Attorney Generals who, the investigators, external investigators, appointed from a list prepared by the Attorney General. So why is it so? Why are there no members of the civil society in the composition of the independent authority? Because we have seen again that all 5 members of the authority are appointed by the Council of Ministers. Now, concerning foreign detainees in our issue number 8, we would like to know whether the code of conduct, which is going to be prepared by the Ombudsman, whether it is ready so that to be applied in these detention centers for foreign detainees, and whether the code of best practices too has been finalized. And finally, on this issue of the IACAP, that is the independent authority, we are told that cases may be referred for disciplinary action to the Chief of Police if the cases are not taken to court. So how many cases have been referred for disciplinary action to the Chief of Police? And generally on this issue of court, of cases going to court, we know that the appointment of members of the judiciary from the Turkish community has been suspended in the constitution. But after so many years, is it not time to have a fresh look at this so that members of the Turkish community in Cyprus do not feel left out as far as the operation of the judiciary is concerned, because they still make up 10% of the population, and it seems that at all levels of the judiciary there are no judges or magistrates of Turkish origin. If this impression is wrong, will you please correct it? And lastly, on issue number 9, about the excessive use of force in detention centers, could you tell us how many such complaints have been received, and what has been the result of investigations on this score? We are informed that according to the report of Amnesty International, which refers to another report, that tear gas was used, that's the report of Amnesty for the period 2014, that tear gas was used against migrants held at the Menoya immigration detention facilities. And these complaints were also received by the European Committee for the Prevention of Torture. I find in your address today, Madam, that you have said that a program of psychological support for detainees and their relatives with the cooperation of the Red Cross of Cyprus is being put into place. So this is a very welcome move on this score. So, and the last question on issue number 9 is we take good note of the measures that have been put into place to prevent excessive use of force in the detention centers, and we would like to know whether these measures are being implemented in practice. So on this, thank you, and I look forward to the replies on these 3 issues.
Thank you very much, Mr. Situl Singh, and now I turn the floor to Mr. Busid. Mr. Busid, you have the floor, sir.
شكرا سيد الرئيس.
Thank you, Mr. Chairman. First, allow me, Mr. Chairman, to welcome, like my other colleagues, to welcome really warmly the delegation of the Republic of Cyprus. I would like to thank them for the fourth report submitted, as well as the replies that they have given us to the list of issues. They are really extensive and really detailed and serious replies, which is a proof that Cyprus is taken really seriously the commitments that it has according to the covenant. Mr. Chairman, I have three questions, number 10, 12, and 13. Regarding question 10, this question is about the extradition, the deportation, and expulsion of asylum seekers. In your reply to this question, you have explained in details the Article 4 of the refugee law after its amendments, and you said that no person is expelled or deported to a country where his freedom or his life will be put at risk or where he will be subjected to torture. Yet we have reports that indicate that the screening procedures that you adopted to identify victims of torture are not in line with the principles that are stated in the Protocol of Istanbul, as the screening and the evaluation is being done by a medical council where we have one physician and one pathologist. They have to make a physical examination, but here only a physical examination is being conducted. The Cypriot authorities have said in 2013 that a psychologist will also be appointed in order to help the medical council look into the allegations of torture. Yet we have noted that a number of cases have been submitted to the medical council for assessment without the presence of a psychologist, and the psychologist was not even invited to take part in the screening process. The reports that we have also indicate that during the assessment and screening process there is no service of interpretation, and some reports states that some children that are aged 13 years have been asked to be themselves translators and interpreters in the presence of their parents, and they would themselves as children detail the torture that the parents have been subjected to, including sexual exploitation. They have interpreted themselves those cases. We have other reports that indicate that the medical council in a number of cases concludes that there are no cases of torture, although some traces of torture are really apparent, even physical traces and marks. We have also some cases that have been rejected when asylum seekers have sent their application to the asylum board, and it turned out later on that these people are victims of torture after independent expert will look into their cases. You have been asked also to mention the countries to which the unsuccessful applicants were expelled and deported to, but you have not given us an answer to those countries. So I repeat this question: to which country they have been deported and expelled? Now, regarding the unification of families and family reunion, the reports that we have indicate that this principle is not respected, and this is why most Syrians do not ask for asylum in Cyprus, because of the lack of family reunification principle. My question is your country resolved to open up the door before family reunification and amend the subsequent law? Now, question number 12. About the detention of asylum seekers and migrants. In your reply, you have detailed all the procedures taken by the state in order to prevent the detention of asylum seekers and refugees, and we would like to thank you for that. But according to some reports that we have, it seems that there is still a regular practice of detention of asylum seekers and migrants. In a report of 2014, Amnesty International has confirmed that the Cypriot authorities on a routine basis do detain asylum seekers and migrants, and all in very poor conditions and for very long periods of time awaiting deportation. Those detainees include refugees, they include women, they have been separated from their younger children, where the number of children that has been separated from their parents is very high, including children that are 9 years old and even 19 months. And two women have bitterly explained to Amnesty International what were the dangerous hazards that have been subjected, that their children have been subjected to after their separation from their parents. The report of Amnesty International refers that later on the two women have been released, this after 4 weeks of detention. The report of Amnesty International also indicates that despite the fact that the Cypriot authorities have indicated that they have alternative measures to detention, yet this alternative and this option is rarely provided and granted. Information also indicate that a number of Syrians have been detained despite the fact that the formal policy of Cyprus is not to extradite or deport or expel Syrians to their countries. It seems that a very limited number of asylum seekers that have appealed their deportation cases is still in detention, as the law permits for the person to remain in detention. And this despite the fact that the European Human Rights Court said that this is against the Article 13 of the Covenant. The directives of the Ministry of Interior do not allow the release of individuals that have then submitted asylum cases after saying that they were refugees. We have also some specific procedures that have been taken against some asylum seekers, including women, children, and victims of torture. My question is, are those allegations true? And is the government ready and resolved to amend the law in order to address those cases I have mentioned? Now, about question number 13. In this question, you have been asked to give statistics about the number and the age of migrants and asylum seekers that are presently in detention awaiting deportation, and about the time they have spent in detention. You have also been asked to give some information about judiciary assistance. In your reply, you did not give us any statistics as requested. This is why I would like to rephrase my question, and I hope that you will give us some statistics as requested in this question. Regarding the question on the judiciary assistance, you said that this assistance is present and available, and this is according to an Article 64 of the Constitution. But the information that we have indicate that the asylum seekers are deprived of judiciary assistance during the preparatory process, i.e. the first stage of file preparation. Besides, the advocate law prevents the provision of any pro bono service in this respect, and even for cases of appeals, then the conditions that have to be met to obtain this assistance mean that in the past 4 years, only one appeal has been accepted per year, because those conditions are really very strict. My question is the government ready to amend the judiciary assistance law so that there is at least one lawyer ready to assist the victims and look into the files of the asylum seekers in all the stages of their files? And thank you, Mr. Chairman.
Shukran, Mr. Boussid. And now I pass the floor to Ms. Cleveland. Ms. Cleveland, you have the floor, madam.
Thank you. I would also like to welcome the distinguished delegation and join my colleagues in thanking you for your very detailed and helpful responses. I'm going to speak briefly to issue number 5 and part of issue number 14. Issue number 5, of course, deals with gender equality and particularly with wage equality and the participation of women in public life. And I would also like to join my colleague in thanking you for your very, very detailed and instructive reply on the participation of women in political life in Cyprus. You've given us information indicating that women occupy a number of senior positions in the government, and then provided encouraging data on women's roles in the civil service, in local government, and in the judiciary. I would just note that the accomplishments are also reflected in the composition of your delegation, which we appreciate. You also acknowledge, I think, very candidly, the significant gap that remains in the continued prevalence of gender stereotypes and patriarchal attitudes. I would appreciate it if you could provide us with specific information about the new national action plan that you are developing with respect to these issues, and in particular, the aspects of the action plan that will continue to combat inequality with respect to the political participation of women. And then with respect to wage inequality and economic inequality, I again understand from Annex 2 to your reply to the list of issues that you have approximately a 16% wage gap between men and women. So I would appreciate more detail regarding what steps you are taking and plan to take to address wage disparities generally, as well as the participation of women in economic life. With respect to issue number 14, I had a few questions regarding investigation and prosecution of deaths in custody, inter-prisoner violence and gang rape, and also the use of solitary confinement. Again, with respect to deaths in custody and particularly suicides, we appreciate the very detailed description you've provided of the reforms you have undertaken recently to prevent deaths in custody and suicides, including in your opening remarks your efforts to develop guidelines under various international instruments reflect a very positive step. And this is also an issue that has been the subject of detailed recent review by the Council of Europe's Committee for the Prevention of Torture and also the Committee Against Torture. So it has been somewhat difficult for us, I confess, to figure out the timing between the recommendations that have come from those two bodies and the reforms that you have made, and to what extent their findings have been mooted by changes that you have made more recently. So I would appreciate it if you could provide us with information, including statistics regarding the number of recent deaths that have occurred in prisons, including the cause of death, any prosecutions and the results of those prosecutions that may have occurred, as well as data on recent incidences of self-harm and attempted self-harm by prisoners, and also whether you have fully implemented the recommendations of the European Committee on the Prevention of Torture's report in paragraph 77 regarding establishment of a suicide prevention protocol, and if not, what further steps you are planning to take. With respect to inter-prisoner violence and gang rape, obviously there was a very high-profile incidence of gang rape approximately a year ago. We did not receive that much detail on this issue in your reply, and I therefore would appreciate your providing the committee with more detail about the steps you are taking to prevent and monitor inter-prisoner violence, as well as the steps you take to investigate and punish inter-prisoner violence when it occurs. And if you have data on the incidences of prison rape and other forms of inter-prisoner violence, we would appreciate that. And finally, again, with respect to solitary confinement, we welcome your report of the positive developments you have taken with respect to solitary confinement, including the fact that it is used only as a correctional measure in serious cases and is limited in most situations to no more than 2 days. I would appreciate clarification on what you consider serious cause or a serious case that would warrant solitary confinement, and provide us with data on the number of individuals placed in solitary confinement and the length of time they are detained there. I'm also interested to know to what extent individuals can continue to be placed in solitary confinement at the discretion of a prison official. And then finally, what steps you are taking to secure the legislative reforms with respect to solitary confinement that were recommended in paragraph 15C of the concluding observations of the Committee Against Torture in July of last year. Thank you.
Thank you very much. And maintenant, je passe
And I'll give the floor to the next speaker on my list, Mr. de Frouville. Mr. de Frouville, you have the floor. Thank you very much, Mr. Chairperson. I also wanted to extend a word of welcome to the delegation of Cyprus and thank it for all of the information provided, both in the replies to the list of issues and in the introductory statement provided by the head of the delegation. I would like to go back to the issue 6 and supplement what was said by my colleague Sarah Cleveland concerning certain parts of issue 14. First of all, in issue 6, the committee asked the state party to clarify what measures have been taken to ensure that children of women with internally displaced status are given the same status and benefits as children of men with internally displaced status, above all with regard to voting rights, social benefits, and housing assistance. You provided an answer in paragraph 33 of your replies to the list of issues. This reply indicates that we can deduce that the problem has been resolved, at least in part. I would like some clarifications on this at any rate. You point to the adoption of a legislative amendment published in the Official Gazette on December 27th, 2013, concerning existing benefits, the children of IDP fathers and mothers. It seems that this principle of equality between children of IDP mothers and fathers relates to benefits. So I would like some clarifications from the delegation concerning the benefits referred to and covered by this equality principle. The second question, which remains, therefore, as suggested by paragraph 34 in your replies, is the following. The question of persistent inequality concerning the right to vote, because it says that as far as electoral rights are concerned, children of IDP mothers are registered in the electoral list of their residential address, whereas children of IDP fathers are registered in their father's place of displacement. This makes us conclude that the children of IDP mothers do not have an effective right to vote. So there is continuing inequality in that respect. So I would like to know what measures you have planned to introduce to reestablish equality from this point of view. Concerning issue 14, here my questions have to do with detention conditions, overcrowding, the degree to which detention conditions comply with international standards, particularly with respect to the detention of migrants. I think that we can only be gratified by the progress that's been made and that you indicate in your reply concerning detention. And this was in the replies and also your introductory statement, Madam, concerning the detention of migrants and the fact that detention facilities in the central prison, which clearly were not intended to accommodate migrants, had been closed, and that the Menoya prison is not overcrowded. It's even under-occupied. And in your statement, you pointed out that the police in this detention facility of Menoya is implementing a psychological treatment program, and this is all very positive. And here I refer to the concluding observations of the Committee Against Torture. It seems that the detention conditions in this Menoya detention center do not fully comply with international standards. I wanted to know what measures you plan to apply to follow up on this European Committee Against Torture recommendation in a recent report published in 2014. In your reply, you also say that there still is overcrowding and probably a problem of detention conditions, above all due to the fact that when we're talking about the central prison, well, we'll talk about this tomorrow further, due to the fact that minors continue to be kept in this prison. You note that for a capacity of 340 prisoners, you have some 600 prisoners there. So I wonder what measures you've planned to introduce to resolve this problem. Thank you.
Merci beaucoup.
Chairperson, thank you very much.
Bien, no veo.
Well, I don't see anyone else from the committee requesting the floor. No colleagues. I just want to check that no colleague wants to speak. We are doing very well with our time. Well, I'll give you 20 minutes approximately, delegation, so that you can organize your replies. And obviously, colleagues will have a chance to ask follow-up questions concerning this first part of our dialogue. So 4:40, 20 minutes to 5, we'll come back to continue with our dialogue. The meeting is suspended until 20 to 5.
Muy bien, colegas.
Colleagues, let's resume the dialogue with the distinguished delegation from Cyprus. I know that they've prepared the answers to the questions that were addressed to them by members of the committee. So without further ado, I would like to give the floor to the distinguished head of delegation to answer.
Thank you, Mr. Chairman. First of all, I would like to thank all members of the committee for these constructive questions, which we will all try as a team to reply to you as frankly as we can. I myself will try to deal with issues of more general nature, whereas the other members of the delegation who represent the experts from the departments, they can give you specific information and data. It's issues they know much better than me, and of course it's natural they should give you the information and data which they have. First of all, I would like to thank from the bottom of my heart the members, all you who have expressed who said kind words about the quality of our report to you. The intention of Cyprus, and myself personally as being the official entrusted with that, is to be frank with the treaty bodies, because we honestly believe that this is a process that allows us to evaluate what has been done and how can improve. And I can assure you the way these reports are drafted, it's getting together the government departments, giving them an opportunity to put their heads together and try to think what we have done and how can improve the situation. I owe you an apology to this committee because, yes, we have been delayed to an embarrassing situation, and I feel very embarrassed towards your committee. It's the only treaty body that this has happened. There is no excuse, but this is due to bureaucratic deficiencies encountered in small countries with administrations that have to deal with a number of issues. As I say, it's not given as an excuse, it's just an honest answer. But I thank you, as I say, we try to be frank, and I thank you for your comments. Now, the Ombudsman's Office, you are very correct. This institution, which does very good work, is being given a number of competences that in any other country would have been given to different people and different institutions. Again, we're a small country with limited capacities. I'm not saying that we don't have other human resources. Other people could do things. It's limited financial resources, especially in recent years, and you're all aware of that. The Ombudsman, as an institution, has been doing very good work, and it's been respected by the society, and increasingly so by government departments. The Parliament, there is a special parliamentary committee which exercises parliamentary control, which has on its mandate, on its terms of reference, the work of the Ombudsman. So it is effective as an institution like the Ombudsman. It's structured on the basis of the Scandinavian Ombudsman can be. It has impact in the society. It's embarrassing for the government not to buy it. So again, yes, this is the reason that more and more authorities, which in the eyes of the executive power are considered to be similar human rights, respect of human rights, that given to this institution. You are correct. It should be having more staff. But again, given the situation for Cyprus in recent years, even the Ombudsman herself did not ask for more staff in the last 2 years. And she did not ask an increase for her budget. They are doing very good work. This is why I myself, being an independent institution, as law commissioner, having the mandate to advise the government on the level of respect of human rights and how to improve our situation, and the president directly, I always give in the reports we submit the views of the Ombudsman and what has been done to comply with the Ombudsman. Another issue is the question of languages. Yes, the Ombudsman, like other institutions in Cyprus, the Commission for Children's Rights and others, we all try to have Turkish language on our website and in the report to issue. This has a practical difficulty. Our Turkish compatriots do not participate, as from 1964-65, in the branches of government. We cannot have members of our staff as Turkish Cypriots, and this replies to the question put about the judges, and I will come to that later on. Therefore, it's not easy to get your reports done in this language. unless you try with private translators, and again, you run the risk of not being able to correct. But this, it's a technical, practical difficulty for that. I'm sure it's not an intention of the Ombudsman for that, the languages. The question of the accreditation of the Ombudsman. The application has been filed, and it's in the process of being examined by the Office of the High Commissioner. I am in a position to know that they have been asked, the Ombudsman, to submit some of their documents, their laws and some other documents in English and or French, and this is in the process of submitting this. They're technical issues. They will be examined, I think, in the next session of examination of institutions to be accredited, and they're under the impression that their reply will be favorable. Corporal punishment. The question is very valid. The real situation is that corporal punishment has been banned from Cyprus for many years, for the last 10 or 15 years. And Cyprus, in all our reports, have been reporting that the corporal punishment was prohibited in the family and in schools. As far as the family area is concerned, we have very good laws since for the last 10 years, the family violence legislation, which strictly prohibits corporal punishment and any form of violence within the house, including psychological punishment, and it makes it a criminal offense for anybody to whom comes to the attention of any person who becomes aware of the fact that there is violence in the family against children or invalid people, not to report it to the police or to the authorities. There was this Article 54 of the Children's Law in that law, and for this reason, that NGO, international NGO for the banishment of corporal punishment, was insisting, and rightly so, that this be abolished. Again, it was not implemented, it could never be implemented, because for families it was repealed by another law, and for schools there were school circulars prohibiting that, and it could never be implemented. It would have been a criminal offense under other laws for any teacher or member of a family to do so. But yes, it was there. The reason they did not proceed to change it, and I'm fully aware of them because I know the new laws, because they are reforming the whole legislation on children. Perhaps this will come up at the questions to be raised tomorrow, and you'll have a more elaborative answer on that. The whole legislation on children is revised. It's in the process that drafts have been made. But it was correct that it had to be deleted from the Strasbourg book. But the fact remains that it was never implemented for the last at least 10 years. It would have been a criminal offense under other legislation. Now, domestic violence as a whole. As I say, we are one of the pioneering countries in the European continent that we have very good legislation since for the last 10 years, which makes very good infrastructure to combat domestic violence. Yes, there are more complaints, and I think we should be happy for that. Because of the awareness raising, and because of the existence of institutions to support families and women and children who dare to speak out and to shelter them, women find it possible to come out and speak about that. And this is a positive. I think family violence, like in any other society, has been there for ages. It's the new legislation, the new infrastructure, the awareness raising, and through the media, and many spots that now they're increasing now in the media, particularly on TV, calling upon women to speak, not to accept any form of violence, including psychological, which is not easily recognized psychological violence. They find it possible to speak. What happens thereafter with prosecutions, it's another story. Mrs. Dimitriou from the Ministry of Justice may say a bit more. You know how criminal procedures are, where you have to prove beyond reasonable doubt under our system, and often it's a question of how the evidence is assessed, especially if we're talking about psychological violence. And often, and not often, in some cases, your witnesses, being the victim, may withdraw. But it's an issue, we have to look into it, and it's very correct you're raising this. It's an issue how we're going to empower and how to change attitudes and cultures, and perhaps to see into the legislation to make it easier to convict, of course, without violating other issues of human rights, like the presumption of innocence of any person until proven beyond reasonable doubt that one has committed any criminal offense. This is explanation I could give on this general issue. On the issue of the missing persons, this is an issue that one has to understand the whole background. The committee of the missing, the issue of the missing persons, it's an issue which is it's a humanitarian issue that has affected both sides of the island. Greek Cypriots and Turkish Cypriots in different numbers. But it's there and it's hurting families on both sides of the island. And it's a humanitarian issue. For this reason, the Committee of the Missing Persons was established under the auspices of the Secretary General of the United Nations. It's composed of a Greek Cypriot expert, a Turkish Cypriot expert, and an international expert who is nominated by the ICRC, International Committee of the Red Cross, and appointed by the Secretary General of the United Nations. They work in harmony. They work in harmony, but their mandate is limited. Their mandate is to identify the remains, and this is a problem, and not to investigate the causes of the death and to attribute responsibility. This is a problem, and the government of Cyprus, which is today under review, it's pressing for this to change, but there it is. Another thing I want to point out for your committee, it's perhaps to make it clear, I'm sure you know it, but to point it out, is that the judgments of the European Court of Human Rights, the ones that found a state responsible for violating the human rights of the families of the missing persons, are judgments against Turkey. What is happening in the north? There have been attempts to, and cases brought before the European Court against Cyprus, which is under review today, but these have been dismissed. Because, and I say in all honesty, that the government of Cyprus throughout these years, not today's government, Cyprus throughout this year, has been exerting all effort to find the truth about these people. It's a tragic history, these are tragic situations, and unless they're solved, and by not solving them, it makes it more difficult to solve the whole of the Cyprus issue. I have statistical data as at September 2014, last September, but this is an ongoing process. As to Greek Cypriots, from the 1,619 missing persons, now as we still do not know the fate of 1,175 people. And of the Turkish Cypriots, which were 502 people, we still don't know the fate of the 174 people. So more have been found out. For the Turkish Cypriots, the work is done in the area which is under the control of the government of Cyprus. And every effort is made to allow the work of the Committee on the Missing Persons to do its work. The problem and the reason that there are over 1,175 Greek Cypriots whose fate we cannot has not been ascertained by the Committee of the Missing Persons, which is an independent committee, as I said. It's because there are obstacles from the occupying state. That's why I found it necessary, even in my opening remarks today, to remind you of the situation in Cyprus, even though I'm aware we said it in the report submitted to you. Cyprus has made available to the Committee on the Missing Persons all archives about the situation of the Turkish Cypriot in what you term as the southern part of the island. But Cyprus has also appealed constantly to the Turkish government to make available to the Committee of the Missing Persons, not to the Cyprus government, the archives of the military in 1974. So this work will continue. There was a very good question welcoming the visits of pilgrimages, whether this would make it easier for the Committee of the Missing Persons. Unfortunately, there can be no relevance because of what I said before. But that's a very valid question. Again, there was a valid remark that there are no judges of Turkish origin now in the judiciary of Cyprus. This makes it possible for me to refer you to the structure of the state of Cyprus. Cyprus was established in 1960 as a result of the London and Zurich agreements, political agreements, on the basis of which a constitution was drafted, which was adopted. This constitution created a bi-communal state, and the representation in the organs of government, the executive, the legislature, and the judiciary, was bi-communal, 7 to 3%. So there were great circus judges in all branches of the judiciary and as in all other branches of government. After the intercommunal problems in 1963 and 1964, the Turkish community, as a community, not the individuals, withdrew from the branches of government. We ceased to have ministers in the government, we ceased to have members of parliament, we ceased to have members of the judiciary. So thereafter, by invoking the doctrine of necessity, legislation was enacted in deviation of the constitutional provisions, making it possible for the state to function with only one element, the Greek Cypriot element. This is the reason it is functioning now. We all hope that if we have a settlement and a new state of affairs, it will be able for both main communities and for all communities in Cyprus to participate again in the organs of the government, the branches of government. The civil society, it's getting closer and closer in recent years. Civil society, there are a number of civil society activities and women activities. I'll come to the gender perspective, which was very validly raised today. What do we do about the peace process? There is increasing interaction between political parties and the women's branches of political parties, but also within the civil society, and younger people, younger than my generation, who do activities, and this will help. If people and the society get together, it will help. And maybe politicians will find it impossible in the future not to find a solution, I hope in the near future. But this is a situation that it's a fact. There are a number of activities under the auspices of the United Nations, under the UNDP Act program in Cyprus, and all these are for the benefit of both communities. And a number of these activities are within the auspices and the framework of the talks, even when the talks at the politicians' level are not continued. These activities continue to take place. As to the gender perspective, all remarks were very valid. There is effort to change issues relating to gender equality, the gap about representation in the government. Yes, there is an increasing number of women at high posts in the public sector, including the judiciary. One reason being the evolution of things, because the new generation of women have all tertiary education in the same numbers, if not more than men, the generation. So an increasing number of women now are found in high posts in the judiciary and the executive. But there is still a lot of work to be done. And to fill the gender gap, I hope the expert from the Ministry of Labour will be able to give us specific information on that. You are very correct in pointing out the action plan on gender equality, which has been evaluated, and the evaluation of that has been taken into consideration in developing the new National Action Plan for 2014 to 2017. But what's equally important is the fact that in the strategic plan for women, for equality of women, which was drafted recently, taking into consideration all the recommendations of the CEDAW committee, and giving the views of actions, giving all actions that will be taken on board to implement the recommendations of the CEDAW, which of course aim at gender equality in all areas, has taken into consideration the evaluation of the National Action Plan on Gender Equality, which has been evaluated. I think I will stop here and give the floor to my colleagues from the government departments to give you more specific information. Perhaps tomorrow I can give you more if you like.
As regards domestic violence, I would like to say that the National Action Plan 2010-2013 has been evaluated by the Advisory Committee on the Prevention of Violence in the Family, and specific suggestions were made. Those suggestions, along with the suggestions on the Ombudsman and various reports, are being seriously considered while currently preparing the new action plan on the combating of violence. There is an aim to make this plan more focused and comprehensive, with an emphasis on actions that were not implemented in the previous one. In the framework of revising the manual for interdepartmental cooperation, there are plans to aim for a more coordinated intradepartmental communication for a case-by-case assessment of the danger and severity of the incident. A separate manual for violence in the family against children will be prepared. As regards the issue of reporting, in order to encourage people to report cases of violence against women and children, family counselors accept anonymous referrals. There is also the issue of mandatory reporting. Public officers of the Ministries of Health, Education, Justice and Public Order, and Labor and Social Insurance have a mandatory duty to report to the Attorney General's Office any referrals regarding concerns, suspicions, or evidence of family violence, including domestic violence. Additionally, according to Article 35A of the Violence of the Family Law, any person who omits to report a case of violence against a minor or a person having severe mental or psychological deficiencies which came to his or her knowledge commits an offense. As to the question whether welfare protection is afforded to victims who do not wish to file a complaint, the answer is that certainly. Counseling from welfare officers, information on their basic rights and options, psychological support, and referral to various competent services, like health services, for example, are provided. Migrants are, of course, provided the same level of support as Cypriot nationals. On the question of the gender pay gap, I would like to say that the financial crisis has put the female workforce at a particular disadvantage, since most women are in precarious employment and unskilled or low-skilled occupations or work part-time. Acting for gender equality, and particularly for reducing the gender pay gap, is very challenging under the circumstances. Despite this, the Department of Labor Relations is still implementing the project Actions for Reducing the Gender Pay Gap, which started in July 2010 and will be concluded by the end of 2015. The budget of the project is €3 million and is co-financed by the European Social Fund. The project consists of a broad mix of measures aiming to combat the root causes that create and sustain the gender pay gap. The measures undertaken involve various social groups, such as officers and inspectors of equal pay and equal treatment in employment legislation, enterprises, social partners, and the society in general. The different actions of the project, which are implemented through public contracts, include, among others, the improvement of the inspection mechanisms for equal pay legislation, the establishment of a gender equality certification body, and the examination of the collective agreements for the identification of discriminatory provisions regarding pay. Actions are also being currently implemented in the educational sector, aiming at the elimination of the occupational and sectoral segregation, and include the training of career counseling and educational services faculty, a total of 10,000 primary and secondary education teachers and 5,000 parents. Additionally, the Gender Equality Committee, established in 2002, is responsible for promoting social dialogue between the representatives of employers and the representatives of employees, as well as with non-governmental organizations that have a legitimate interest in promoting equality between men and women. This committee can review the laws and regulations that govern labor relations in relation to matters of equality between men and women and suggest a re-examination. It suggests projects, carries out research, and collects statistical data regarding equality between men and women in employment. It also submits or accepts complaints that relate to the violation of the provisions of relevant legislation, which is then forwarded to the inspectors who are responsible for carrying out the relevant research. It has also been appointed as the competent body for providing victims of discrimination with independent assistance, including legal representation in court. The Gender Equality Committee's mandate has greatly empowered efforts to promote gender equality in the workplace, including pay equality, through a significant number of publications and information dissemination through the media on the subject. This is the information that I have for you today. Thank you.
Thank you very much. I will try to provide you with as much information as possible, and of course we'll get back to you in case I'm not able to answer all of your questions. I will start and inform you basically about issues related to detention of asylum seekers and relevant procedures. Detention of migrants, illegal migrants, is used as a measure of last resort, and it is applied for the shortest period of time possible and only when there is no other less coercive measure available, which would make the effective return of the illegally residing immigrant possible. What is more, detention may only be maintained for reasons of preparing the return process and only for as long as removal arrangements are in progress. These matters are clearly stated in and regulated by the Aliens and Immigration Law and are fully aligned with the relevant EU directive, the Return Directive. In addition, the relevant decision for the detention of an illegally residing person is submitted in writing, clearly stating the reasons, and is also communicated to the person concerned. However, prior to the issuing of such a deportation order, the person concerned is given the option to depart voluntarily within a reasonable time frame. This time frame depends on the individualities of each case, whether the person has children in school, whether there are medical conditions to be taken into account, and so on and so forth. The government of Cyprus is making systematic efforts in order for the repatriation orders to be executed as soon as possible with a view to limit the detention period. In cases where the return decision cannot be effectively implemented, either due to lack of cooperation by the person concerned or due to delays in obtaining the necessary documents, the person is released on terms. Even though the detention period may be extended in cases, for example, when the person concerned has previously committed a serious penal offense and or when there is a reasonable prospect of immediate successful removal, it should be underlined that no person is held in detention for longer than 18 months, which is the absolute longest. In order to ensure proper implementation of this provision, the Minister of Interior regularly reviews all detention orders. This happens every 2 months. What is more, and I would like to underline this, all return decisions are made with full respect to the principle of non-refoulement according to the Geneva Convention of 1951, as well as Article 3 of the European Convention for the Protection of Human Rights and Fundamental Freedoms and Article 18 of the Charter of Fundamental Rights of the European Union. Last but not least, a person awaiting his or her return has the right to challenge this decision before the Supreme Court. As far as the detention of asylum seekers is concerned, if a third country national or somebody illegally residing in the Republic submits an application for international protection while being detained, the deportation order is suspended in order to respect the principle of non-refoulement, as I've mentioned before, in accordance to the Geneva Convention and the rest of the relevant articles. At the same time, the Asylum Service is immediately informed in order to issue a decision under accelerated procedure, so in order to minimize, to the degree possible, the detention of the person. The person shall remain in detention until a final decision is reached according to the refugee law, but if the Asylum Service or the reviewing authority, which is the competent authority to review administrative recourse, does not reach a decision within 30 days, the person is released on terms. Furthermore, it should be also underlined that according to the refugee law, the detention of asylum seekers for the sole reason that they are applying for asylum is strictly prohibited. As far as detention of mothers is concerned, and the possible separation of children, both the aliens and the immigration law, as well as the refugee law, clearly stipulate that the best interest of the child shall be the primary consideration in order to apply the provisions of the two mentioned laws. As we have also stated in our fourth periodic report, there have been no detention orders issued for minors, but also, as the head of delegation already mentioned, as a result of the close monitoring by the Commissioner for Children's Rights, a policy decision has been issued with a view to eliminating incidents of separation of children from their mother or single parent. In particular, in cases where parents of minors, when both detected to reside illegally in Cyprus, a ministerial committee decided in April 2014 that the parent is not put in detention, but is given a right by the authorities setting a date of voluntary departure. Until that date, the parent is allowed to reside with his or her child, of course outside, subject to certain terms. For example, they might have to report to the district police once a month, etc. In reference to Syrians, due to the very, very sad and tragic ongoing humanitarian crisis in Syria, no return order is issued against Syrian nationals. Furthermore, all deportation orders against illegally residing Syrian nationals have been suspended. There is no deportation order pending against a Syrian national. Based on very clear instructions issued by the Minister of Interior, all Syrian nationals who are holders of valid IDs or other documentation, passports, etc., may apply for a permanent, a temporary residence and work permit. This right is given to all Syrian nationals, regardless of whether they have been residing in the Republic legally or not. As far as Syrian asylum seekers are concerned, they have full access to all the rights as defined in the relevant law. And of course, all cases are examined on their own merits. Fully respecting the principle of non-refoulement, rejected asylum seekers of Syrian origin are given the right to apply for the temporary residence and work permit I have mentioned before, based on the fact that no Syrian is returned to his or her country of origin. I would also like to briefly mention something about the family reunification issue that was mentioned. As far as we are concerned, and through the interviews with Syrians, what we have heard is that people who do not wish to apply for asylum in Cyprus do not wish to do so because they have family members in other EU countries. We have not been informed of any case a Syrian national has family in their country of origin they wish to bring to Cyprus. Most of the cases were when they refused to apply for asylum were cases when they had family members in other European countries. The reason they didn't wish to apply was, of course, the restrictions posed by the Dublin regulation. But we have been quite successful with most of their claims so far, and we're still examining more of them. Would also like to inform you that there has been an amendment to the refugee law in order to include provisions for family reunification of recognized refugees, which is not directly related to the Syrians you have mentioned, but it shows that we are very closely monitoring those issues. There was a question about the number of detainees. We would gladly get back to you in writing with an exact number, but of course you do realize that this number changes every day because we try, as I said, to make the detention period as short as possible. Based on the information I have for the past month, the number is less than 100 people being detained awaiting deportation. Not Syrians, I'm talking, there was a general question about the number of detainees as far as I understood. I will let my colleague give you a couple of information. I know I haven't been able to cover all of your questions, but I will gladly try to do that in the next round. Thank you.
Mr. Chairman and members of the committee, I'll try to address as much of the issues raised. I have too many anyway. Let's start from the short replies. As regards the domestic violence, with the question or the comments raised about in the absence of an official complaint, the police does not drops the case. Just to mention here that if the victim, in the absence of an official complaint, the police does not drop the case. However, if the victim has not the energy or the resources, as you mentioned earlier, then it's a matter of proof at the court, and it's difficult to be proved, especially when it concerns the cases of psychological violence. In the absence of victim to continue until the end of the case, it's very difficult to prove a case of psychological violence. In the absence of victims before courts when concerns physical violence, the police does not drop the cases. So if there is enough documentation and evidence, the police submits the case before court, and then it's again upon the court to decide and assess the relevant evidence and documentation. As regards the sentencing policy for offences in violation of domestic law, the sentences are much more stricter than the offences in violation of criminal law, of course. I think we have provided in an annex, I don't remember which annex it's that. So again, the assessment of the evidence is upon the court and then decides about the sentencing, even in domestic violence cases. Now, as regards the issues raised about the independent authority for the investigation of allegations and complaints against the police, let me briefly reply to the issues raised. In 2006, the government took a very important step towards the prevention of the violation of human rights by setting up the independent authority for the investigation of allegations and complaints against the police. The independent authority was established by the Police Independent Authority for the Investigation of Allegations and Complaints law, and it commenced its operations in May the same year. The 5 members of the independent board, as you mentioned, including its president, are appointed by the Council of Ministers for a 5-year tenure. According to the relevant law, the independent authority investigates complaints against the police in relation to the three following categories: corruption, bribery or unlawful enrichment, violations of human rights, and the third one, actions which constitute favorable treatment or undermine the police repute. The investigation of a complaint commences if a written complaint is filed by a complainant, if the Attorney General assigns to the independent authority the investigation of a complaint, if the Minister of Justice and Public Order assigns to the independent authority the investigation of a complaint, by virtue of the independent authority if it becomes aware of an allegation by any means. The complaints are investigated either by members of the independent authority board or other independent investigators who are appointed by the independent authority. These investigators are selected from a list of persons, as you mentioned, which provided by the Office of the Attorney General. And the following mechanisms assure that the objectivity of the investigation of complaints, once the investigator has concluded the investigation, he submits to the independent authority the relevant case file along with his findings. The findings of the investigators are not binding on the independent authority, and the independent authority looks in the case file and draws its own conclusions. Each investigator is subject to the instructions of the independent authority, and the Attorney General and may apply directly to Attorney General for guidance. It is interesting to know that the European Court of Human Rights issued a decision on 18 June 2009 with regard to the application by Morteza versus Cyprus, noting that the independent authority is an independent authority that is not linked in any way hierarchically or institutionally to the police. Additionally, the European Court of Human Rights found that the investigation carried out by the independent authority was sufficiently thorough to meet the requirements of Article 3 of the European Convention for the Protection of Human Rights. Further, the European Committee on the Prevention of Torture and Human Degrading Treatment or Punishment, CPT, during their visit to Cyprus in May 2008, visited the independent authority and commented favorably on its establishment and on the way it investigates the complaints. As regards the issue raised about the criminal and disciplinary cases, after an investigation is completed, if criminal offenses are found, then the case is forwarded to the Attorney General, who has the final word for exercising or not the criminal prosecution. In the case of disciplinary offenses, the case is forwarded to the Chief of Police, who is obliged to exercise disciplinary prosecution based on the evidence obtained by the independent authority. However, the disciplinary procedure is carried out according to the provisions of the police disciplinary regulations, and the independent authority cannot interfere or participate in any way in this procedure. As regards the remarks that were raised on the use of tear gas in Menoia detention facility, just allow me to say that as a general rule, the use of tear gas as a practice is avoided, and it is used as a last resort, and when only it is strictly necessary under specific provisions. Tear gas is used only by special trained members and when conventional policing methods have been tried and failed. Also, when there is no alternative option to address the situation, and if the use of tear gas will cause less harm. As regards the incident, it was investigated by the Ombudsman, and it was assessed that the police officers react proportionally to the incident. Allow me to. As regards the ill treatment of migrants in Menoia, strong recommendations were made to the staff of the Aliens and Immigration Service that in any case that a violation of human rights occurs during the execution of their duties, the service will demonstrate zero tolerance. The police is sensitive on issues regarding ill treatment, a use of force by members of the police. Mennoia Detention Center is often inspected by the Ombudsman, Cyprus Red Cross, Parliamentary Committee of Human Rights, local NGOs, as well as international European organizational committees and NGOs. For the prevention of ill treatment and torture, the measures and the initiatives launched by the government are convenient with the changing of culture. Our goal is to eradicate torture, ill treatment, and all its forms, which are congruent to the change of culture. Torture, ill treatment, excessive use of force undoubtedly affects fatally public's confidence in police. The goal is build partnerships with the public and civil society in order to create an environment of mutual trust and prevent and combat crime together. Therefore, the government shows zero tolerance to inappropriate behaviors, ill treatment, racist attitudes, excessive use of force, and means of restraint by members of police. Towards this direction, the government has taken the following measures and actions. Any allegation of ill treatment and excessive use of force by police are investigated. Public, civil society, and NGOs have direct access and communication with the Minister's office in order to bring about constructive dialogue and yield concrete solutions to the problems of the people caused by police in a more impartial manner. A high-ranking officer from the Minister's office was appointed as the liaison of the Ministry, police, and public. Inter alia, she manages various complaints made by the public against police, for example, ill treatment, physical attacks, misconduct, corruption, etc. In a year's 1,000 complaints were reported, where some of them were investigated by the police, some others were investigated by the Independent Authority for the Investigations of Allegations Against Police, and in some other cases, criminal investigators were appointed by the Attorney General. In some other cases, the citizens were invited to the offices of the police district as they had a face-to-face conversation with the director. Corrective measures are taken according to the instructions of the Minister of Justice and Public Order. The Minister of Justice and Public Order launched a website to which now citizens have the opportunity to submit their complaints online. Independent mechanisms for monitoring, as I mentioned earlier by the head of the delegation, are strengthened. The Commissioner of Administration Law 2014 introduced provisions that expressly provide the obligation of the competent authority to consult with the Commissioner as to the findings in her report and to provide information as to the actions undertaken to comply with the suggestions therein. When the competent authority does not comply with the suggestions of the Commissioner and the latter considers that the reasons are not justified, then the Commissioner submits the outcome of the consultation to the Council of Ministers and the House of Representatives and may publish the refusal or omission of the competent authority to comply with the Commissioner's suggestions. Additionally, the law introduced provisions that strengthen the obligation of cooperation of every officer in a ministry, department, or independent authority of the Republic to cooperate with the Commissioner and provides that the refusal of such person to cooperate is a disciplinary offense. As regards the detention conditions, whether they comply with international standards or not,
the interpreters apologise interrupting, but perhaps since the speaker is reading out from a written text, she could slow down a little bit to facilitate the work of the other interpreters. Thank you.
Okay, sorry. As regards the detention conditions, that whether they comply with the international standards or not, just to mention that they were assessed by the CPT and they were assessed as satisfactory. However, there were remarks for improvement, and especially about the strict measures that they were implemented at Mennoia Detention Center, that they were not reflected to the detention status of the migrants. Just to briefly mention that the minister reiterates twice with instructions to the chief of police to put in place a program more appropriate to the detention status of the migrants. As regards the questions raised about our prisons, about overcrowding, suicides, solitary confinement, and any statistics about recent incidents of self-harm. And as regards overcrowding in prisons, just to mention that the capacity of prisons in 2012 was approximately of 340 inmates, and the year ended with a prison population of 694 inmates. These figures can be found in the annual penal statistics of the Council of Europe, Space One, that was released in April 2014. One of our main objectives was to reduce overcrowding to the minimum as it affects negatively the inmates, the services, the activities, and the overall quality of life in prisons. And we have accomplished this with a significant reduction in 2014. As in 2013, the capacity was increased to 413, and during this year, the prison population was still 650 on average. And in 2014, the capacity was increased to 469 inmates. It is interesting to note here that we managed to address this issue of overcrowding effectively, as from October 2014, we have no more than 550 inmates on average. Regarding the measures that we have taken in order to reduce our prison population was the parole board, the electronic monitoring, which was extended to more inmates, but with the amendments of the prison law, the electronic monitoring will be applied to more inmates for longer periods. High-risk suicidal inmates are held in a special unit now, which operates since July 2014. Suspension of sentence, pardon sentence, transfer of persons for serving their sentence to their home country, and construction works which increased the normal capacity of the prison facilities. As regards our prison system now, the over-controlling approach, the detrimental impact of overcrowding and the imprisonment per se, who had taken place the previous years, have promoted the need for a total reformation of our prison system so as to be compatible with the human rights standards and norms. The prison reforms and changes of the first phase of our reforms have been completed with a success, as mentioned and by the head of delegation earlier. The reforms of the first phase were focused on the following areas: improving the detention and living conditions, protection of vulnerable persons, including persons who are considered to be high-risk suicidal cases, change culture of the prison management, and social reintegration. All the measures and changes that we have they have taken place, they have been assessed by the Ombudsman as being in the right direction for compliance with her numerous recommendations contained in a number of her reports in the previous years, which had never been implemented before. Likewise, the National British Academy, parliamentarians from Germany and other experts from abroad underlined that there is a considerable progress in the modernization of our prison system. The change from an over-controlling approach to a human rights-based approach is reflected in the actions taken by the government the last year and a half for the prevention and proper management of such incidents. This approach holds that all forms of ill treatment are unacceptable and they will be severely sanctioned. For the first time, prison officers were suspended off duty, and all allegations of physical ill treatment made by the inmates are under investigation by the prison management, police, ombudsman, or investigators appointed by the Attorney General. In this regard, the determination of the government is demonstrated in the change of the prison administration. the prison director who did not comply to the policy of the ministry was asked to terminate its services. The previous years, the prison policy was designed and led by the prison directors without any interference from the ministry. And for the first time, the ministry designed and monitored the implementation of the prison policy. The Prisons Authority, under the guidance and close cooperation with the Ministry of Justice and Public Order, is now undergoing a considerable restructuring of its leadership and management team in order to ensure that the prison conditions are aligned with human rights standards and norms. The newly appointed prison director has a human rights-based approach, and all her actions are in line with the ministry's policy. All unnecessary control measures, practices, and policies, for example, forced haircuts and shaving, the practice of no visits by the religious representatives, confinement of inmates prior to the investigation of any disciplinary affairs, issues that are mentioned in the previous reports of the Ombudsman, have been terminated. A new humane approach that is compatible to human rights standards and norms is now implemented. There are many examples that I will have the opportunity to elaborate later on that reflect these changes that were taken place. All the measures taken for the reformation of the first phase of the prison reforms, as mentioned earlier, have been assessed by the Ombudsman and are being in the right direction. It is noticeable that for the first time after the implementation of OPCAT, there was an effort for a full compliance with the Ombudsman recommendations. Previously, the decisions that were taken, or those decisions that were not taken as to how effectively manage the prisons, were ad hoc and often poorly thought through. We first conferred widely with the key stakeholders, NPM, CCR, inmates, families of the inmates, prison administration, prison staff, and NGOs, and delivered a reform program of short, medium, and long-term actions which preserve the core principles of a democratic society. As stated earlier, the discretionary parts of prison staff are filtered by the management in accordance with the guidelines given by the Ministry of Justice and Public Order. The solitary confinement is not left at the discretion of the prison officials anymore. The new director, as from October 2014, established a procedure according to the law, and no prison officials are allowed to put an inmate in a solitary confinement or to close an inmate in his or her cell without the approval of the director unless she is informed. Those officials that they do not comply with the new procedure established by the prison director will be sanctioned. The context of confinement of the inmates will soon be amended. The outdated provisions of the prison's law and regulations in relation to the confinement of the inmates will be amended in the framework of the reviewing of prisons, law and regulations, and the policies and practices are reviewed by the expert of the Office of the Minister of Justice and Public Order, together with the prison director, in line with the international standards for the protection of human rights of inmates. An independent committee appointed by the Council of Ministers is going through a fundamental review of prisons, law and regulations, and particularly the...
I do apologize, says the chair. From the Spanish and French booths, please, could you be a little slower, because you're reading out, madam, and at that speed, it's very difficult when it's read out to do a proper interpretation. So again, could you perhaps slow down a little? Thank you.
Sorry. As I mentioned, an independent committee appointed by the Council of Ministers is going through a fundamental review of prisons, law and regulations, and particularly the disciplinary system, in line with international human rights standards and norms, and with the case law of the European Court of Human Rights. Every month, the Council of Ministers is informed about the progress of their work, which will be completed by the end of May 2015. And part of their work can be used effectively in combating torture, ill treatment, and any form of inappropriate behavior, and also in tackling corruption in prisons. As regards about the new policy of the new director with regard to visits, access to telephone and feedback to inmates, application and requests of the inmates. All these procedures were reviewed and changed in order to ensure clear and impartial procedures in the benefit of the inmates. The procedures for the closed visits, as were repeatedly mentioned in the Ombudsman's reports, are terminated. The glass partition that separated the inmates from their families has been removed. Now the rule is for open visits to all inmates. Inmates who have children are allowed to have visits in the area of the open prison or in visiting areas of the closed prison that they have a child-friendly environment. Inmates are now allowed to have visits from all religious representatives, other than the officially appointed clerical for the Christian Orthodox Church and the Imam, following the requests of the inmates. As from December 2014, the newly appointed director has increased the visits from 4 to 10 monthly. During the Christmas holidays, she allowed inmates, females and males who are relatives, to spend time on Christmas and New Year's Eve in a sibling-friendly environment. And the visit guide is prepared and it will be released soon. As regards the telephone calls, the procedure for the reduced number of telephone calls are terminated. In 2014, all inmates had access to telephone calls, and the number of calls were increased from 6 to 10. However, now, with the new director, the inmates have free access to the telephone booths from 8 o'clock in the morning until 6 o'clock in the afternoon. Also, the duration of the calls is increased, and in many cases, the time of calls is allocated according to the individual needs of the inmates. Additionally, access to phone calls is provided to those who have issues with their children or receive infrequent or no visits, and according to the time zone of their countries. As from January 2015, she allowed the use of Skype in order to help inmates maintain links with their families, especially in cases where an inmate is not receiving visits from family and or friends because of distance, lack of transport, lack of funds, or any other valid reason. The inmate or his visitors may apply for family online contact. The procedure is regulated with an informational leaflet that it was delivered to the inmates by the director. Feedback to the request of the inmates. This is also a measure for the prevention of any discretionary actions taken by the prison officials, and as they had no feedback before, new procedures have been established, and the requests of the inmates are now recorded. In due time, inmates receive feedback from the prison management. The inmates have the opportunity to refer to the liaison officer appointed by the prison director, who communicates daily with the expert of the minister's office. And with the establishment of this office, the new director addresses the request of the inmates and their relatives effectively. A prison officer receives the request, and after review, he directly refers to the director, so as the inmates to have another channel of communication with the director. The director herself, along with the expert of the minister's office, occasionally visit all the areas of the prison establishment and meet with the inmates. In the framework of our modernization of our prison system and for the well-being of inmates, we are currently implementing let's say, satisfactory and balanced program of activities, work, education, and sports. The newly appointed director recently asked from the Ministry of Education to update and revise the school program of the inmates so that the education of prisoners shall be as far as practicable integrated with the educational and vocational training system of the country, so that after their release, the inmates may continue their education and vocational training without obstacles. With the attendance of classes, the inmates will be provided with certificates by the Ministry of Education and Culture, with which they will be given the opportunity to complete the program at schools following their release. And now particular attention shall be paid to the education of young prisoners and those with special needs.
If you allow me, I think we have given quite a bit of information on prisons, unless I'm being distracted by the chair, but we've said quite enough on this issue. We have information on free legal aid and victims of torture, translation services and citizenship. If you can give it maybe in 5 minutes, perhaps it will be better, I don't know, for the members. Oh, this is the instructions from the chair.
Oh, the microphone, please.
I would like to talk a bit about the suicide prevention, okay? In the context of suicide prevention, we have taken preventive measures and actions. We have established new procedures on admissions. Interviewing each inmate on admission. Specific instructions are recorded every day for the vulnerable persons of each wing and are disseminated to the heads of the shifts. There is a daily communication and sharing and exchanging of information between the prison management and the prison doctors. And in this context of suicide prevention, self-harm, etc., issues related to this matter, and such, identification of inmates under suicidal risk, development of interpersonal communication skills are now comprised in the training modules of the prison staff. Just to mention that a special facility which started its operation in July 2014 accommodates inmates under suicidal risk. The prison officers who staff this unit have undergone a 2-week intensive training designed by the experts at the psychiatric facilities. And just to mention that the solitary confinement unit as from December 2014 is transformed to a unit that accommodates vulnerable inmates or inmates that they need protection from other inmates. For example, there might be a sex offender that might need protection. So it's placed in this small unit with intensive monitoring by the prison officers. Just to close with the statistics with the self-harms and attempts of suicide in 2013, because prior to 2013 no statistics were kept. In 2013 incidents of self-harm were 56 concerning 14 inmates. Attempts to suicide were 13 concerning 11 inmates. Suicides, there were 3. In 2014, there were 2 suicides, 34 incidents of self-harm, and 5 attempts of suicide. As from October 2014, no attempts of suicide or suicides were recorded, or any incidents of self-harm. So, thank you very much.
Okay. Muchas gracias.
Thank you very much. As part of our procedures, quite apart from providing the information on the procedure, it's extremely useful to have specific answers to the specific question, because that enables the dialogue that we're trying to achieve here. We've only got 2 minutes remaining to wrap up for this afternoon. Of course, we'll continue tomorrow with more questions, follow-up questions. Let me also inform members of the committee there is something related to the afternoon meeting. This is a public session, so I won't give you details, but tomorrow afternoon we'll be examining communications. You should have the respective files for those communications. And we'll be starting with case 2, number 2 in your files, in file 1. And then we will go through our customary order, and there's a reason for this. It has to do with general organization of our work. Mr. Benachou. Thank you, Chairman. We've only got 1 file, yes, with 4 cases. That's all we have, yes? I just wanted to clarify that, Chair. Yes, that's the case, as the Chair.
Thank you, Mr. Chair. I wanted to second the observations that you made about the responses to the next set of issues. I fear that if we will continue discussing details in a very informative way, but at a rather technical level, we would not have time to discuss some of the substantive concerns that our committee has with respect to the situation in Cyprus. So you have the option of providing us in writing after the dialogue, 48 hours after the dialogue ends, more specific information. So I would encourage you for the next round to limit yourself to responding directly to questions and try to avoid reading lengthy pre-prepared statements which you can submit, as I said, in writing. I think that would improve the dialogue for tomorrow. That's why I wanted to say this before we break. Thank you.
Thank you very much. Well, Sonja.
It's 6 p.m. So we will adjourn for today, and we will continue tomorrow morning with follow-up questions. And once we have answers to those, we will move straight on to the second part of our list of issues. So have a restful evening and see you tomorrow morning at 10.